Good afternoon. Welcome to the Long Live Third Parties podcast. Free Press Media Press Inc., a third parties books publisher, sponsors this podcast. I'm Andrew Bouchard. Today I read the case Candidacy of Independence versus Kiffmeyer, 688 NW 2D 854, Minnesota Supreme Court, 2004. Friends, we're going to talk about Minnesota politics again. This case is in Minnesota, where I lived from 2004 to 2012. So shout out to all my friends in Minnesota, and shout out to all my friends in other states and nations. This case happened towards the end of 2004. I moved in 2004, as I recall. I believe it was October-ish. So this barely overlapped with when I would have gotten there. This case involves our friends at the Independence Party. Remember the Independence Party? They're the party that won the governorship in Minnesota. So don't you ever say third parties don't win. They do win, and that was a major race. We got prime evidence. If it happened again, if it happened then, it can happen again. What happened in this case? Let's read from the record. It says, quote, on September 21st, 2004, James Moore, David Allen, and Maureen Peterson filed a petition under Minnesota Statute 24B.44/2002 requesting an order directing the respondent, Mary Kiffmeyer, as Secretary of State of the State of Minnesota, to place the names of the Independence Party nominees for the Minnesota House of Representatives and the United States House of Representatives on the November 2nd, 2004 general election ballot. The Secretary of State had previously notified the Independence Party that its candidates would not appear on the general election ballot because none of the candidates had received the minimum number of votes required by Minnesota Statute 24D.10 subsection 2 in the September 14, 2004 primary election. After the party and amicus curiae American Civil Liberties Union of Minnesota, ACLU Minnesota, filed legal memoranda on an expedited basis, oral argument was heard on September 27, 2004. End quote. Mary Kiffmeyer is facing this lawsuit again. Last time on this podcast, we did a case, Ido Sogi versus Kiffmeyer. So I'm glad the third parties are challenging the Secretary of State of Minnesota here. I'm also glad to see that the ACLU signed on as amicus curiae brief. I like what the ACLU has done in its history. I believe it represents the best of leftist views. In more recent times, there's something that didn't resonate with me, but I'm glad to see in this case they're doing the right thing. This case goes on to discuss how Minnesota has a certain law called the primary threshold law that prevented our friends at the Independence Party from getting on the ballot. This law seems to differ from the ballot access laws in other states. This seems to be unique. As they describe it, this threshold law mandates that a party has to get a certain percentage of votes, which is 10% of that. It says of the voters, candidates in the last election, in the primary. And if they don't get it in the primary, then it becomes an issue where they can't get on the ballot. And furthermore, if one candidate gets that threshold, the entire party does. But if the party doesn't, none of the candidates get to be on the ballot. They mention that what they call the three major parties got on the ballot, which of course were the Republican and Democratic Party. Who was the other major party? the Green Party. So congrats. Congrats to the Green Party for getting on the ballot. It would be heavenly if the Independence Party got on the ballot too. So because in this election, none of the Independence Party got enough of the votes, so none of them got to be on the ballot. So this case centers on the constitutionality of that law. There are other issues the parties raise, but the court says we're not going to decide on those because the constitutional issue is the key issue. Our friends at the Independence Party invoke what amendments? The First Amendment and the 14th Amendment. This theme is popping out at me like a flashing light in these ballot access cases. First and 14th Amendments. First and 14th Amendments. First and 14th Amendments. So way to go, Independence Party. They mention something that unfortunately is pulling the Green Party into this. They say, quote, according to the petitioners, the two old and well-established major parties easily satisfy the threshold, but the statute imposes an unfair burden for less established major political parties. Disparate treatment is also evidenced, petitioners assert, by the fact that the Green Party was able to satisfy the threshold with only 35 votes, but the Independence Party was required to receive over twice as many votes in the same district. End quote. So unfortunately, in a way, this pits the Independence Party versus the Green Party. We don't want to pit each other against each other at this point. I imagine in the future when third parties reign, there's going to be disputes amongst each other. But for now, we don't want those disputes to reign supreme. So, but they do have a point. It seems odd that the Green Party would only need 35 votes, but they would need more than 35. They would need 70 plus votes to get on the ballot. They mention how they have gotten enough support in the past, so they should be on the ballot. So that is good. They mention it is unfortunate that they have more backing than the Green Party, but they don't get on the ballot, but the Green Party does. Although it's a good thing the Green Party is getting on the ballot, we want the Independence Party to get on the ballot too. They do mention how the other way to get on the ballot, which is often in the cases in the other states, is the petitions. Is because of this law, it makes the time frame to get the petitions more challenging. How do you think the court decides this matter? From hearing these cases, you might get cynical. You might get down in the dumps. You might get depressed. You might lose hope. But guess what, friends? I got something to read to you. Let's read. It says, quote, in light of these characteristics of the challenged law and the unusual circumstance that the state, through Respondent Secretary of State and her counsel, the Minnesota Attorney General, acknowledges that there is no rational state purpose served by the primary threshold law, we need not engage in the weighing of burdens and the state regulatory interests prescribed in Timmons. In absence of any suggested rational purpose for the law, we have no difficulty concluding that by denying Independence Party candidates access to the general election ballot, the primary threshold law violates petitioners' constitutional rights to vote and associate for the advancement of political beliefs under the First and 14th Amendments. On that basis, we order the Secretary of State to certify the candidates of the Independence Party who received the most votes in the primary as the nominees of that party for placement on the general election ballot. Petition granted. End quote. Awesome. Awesome. Imagine the exhilaration that would fill your mind, body, and soul if you got up to the Supreme Court in your state and they deemed an anti-third party law to be unconstitutional. And they deemed you to be on the ballot. Imagine that exhilaration. So way to go, Independence Party. You did the right thing. You got ahead. You demonstrated assertiveness, and that assertiveness paid dividends. Long live third parties. Goodbye.